planning do I need a will? My name is Sadie Kennedy. I'm an attorney with the law firm Baum. One question I'm commonly asked is whether or not a person actually needs a will. I'm going to talk about a few of the circumstances under which I recommend having a will prepared. The first is, do you have minor children? A will provides you the opportunity to determine who will serve as your child's guardian in the event you pass away. You will also select a person to manage your assets for the benefit of your child. You can select the same person for both of these responsibilities or different people depending on your circumstances. The other important reason to prepare a will if you have a minor child is to select the age and circumstances under which your remaining assets will be distributed to your child. If you wish for your child to receive the remaining assets at an age beyond 18, it is best to set this out in a will. The next instance in which you should consider a will is if you wish for your assets to be distributed in any way which is different from the way they will be distributed under intestacy law. There are default rules that set out how assets will be distributed if you have not otherwise set out. In general, intestacy laws provide for your assets to go to your spouse if you're married, your children if you have no spouse, if you have no spouse and no children, to your parents, if you have no spouse, no children, and no parents, to your siblings, and so on. The structure works for many people, but not everyone. It's important to take a look and see if you have something else in mind. There are many ways to distribute your assets, and you can decide to do so however you wish. You should consider having a will prepared if you have a preference as to who the personal representative, also known as the executor, of your estate will be. Depending on your situation and your family dynamic, there might be some who are better suited than others to serve in this role. It's important to have a will if either you or your spouse were previously married, or if you have children that are not together. Depending on your family structure, a will can be very important. One example is that the default rules do not include stepchildren as children of beneficiaries as to their step-parents' estates. In order to do so, a person must have a valid will. There are many other reasons to prepare a will. The most important consideration is if you have a reason to believe you want to make a decision rather than relying on the general rules. For more information, contact the attorneys of Baum at 541-963-3104 or visit us on the web at www.baumsmith.com.